Welcome to Vermont Law Review's Disclosure Debates, our 13th annual symposium. My name is Ariel Solaski.
And my name is Anna McMonagle, and we are the Law Review Symposium editors.
We are thrilled to have an amazing group of speakers all day today, and we want to maximize the amount of time to hear their ideas and what they're going to be talking about. So we won't be giving full introductions before every panel, but in your printed program is a full biography for all of our speakers. So we encourage you to look at that and see everything that they've all done.
And finally, we really hope that you will engage with our speakers today and ask them some tough questions. And now, we would like to introduce Vermont Law School's President and Dean, Marc Mihaly.
Welcome, everybody. Glad you're here. At least it's not too beautiful outside. Before I had the great pleasure of coming here to teach, I was actually a lawyer for 30 years, and I spent 25 years of that time representing environmental clients, usually community groups, activist groups, or cities that were under siege for trying to do something environmentally interesting or aggressive. And you know, when you spend a lot of time in the trenches doing that, there's plenty of time to get cynical about things. And you can certainly be cynical about disclosure, because disclosure is often used as a substitute for hard rules. People prefer, I'll just disclose, and that's enough. On the other hand, disclosure is an incredibly powerful tool, and so you sort of go back and forth. And I'll just tell you where I landed with respect to environmental disclosure, because it's pretty easy for me to describe. You know, there's a lot of truisms that aren't true, and there's some truisms that are, and one that is, I've concluded, is knowledge is power. That is true. And in so much of the modern world, citizens, normal citizens, activists, people who do not have a lot of money, they can't generate the information they need in order to make their arguments. It's too expensive to generate. And I found that the great value of the National Environmental Policy Act and my little NEPA in California, CEQA, the great advantage of it was that it essentially just gifted us, you know, citizens groups, it just gifted us millions of dollars of information that we would have had to spend enormous amounts of money to generate ourselves. So at least in the context of my practice, it was essential, because we were able to use that information. Even sometimes models in the appendices of these documents, there was incredibly valuable information. So, but on the other hand, in other areas, maybe it's a substitute, it's a sort of soft approach rather than the hard approach. So today, what I think you're going to hear from the speakers, the lunchtime speaker, from the panelists, you're going to hear different angles on all of this. And I welcome you, and I'm glad you're here, glad you're coming. And I want to turn it over to Professor Janet Milne, who will do a real introduction.
Do we have a clicker? Thank you very much. So, welcome. Today's topic of disclosure covers a multitude of virtues and sins. So I thought it might be useful to go up to the 30,000-foot level, for starters, to look down at the topic from the distance. In the 1700s, Samuel Johnson said, quote, "Knowledge is of two kinds. We know a subject ourselves, or we know where we can find information upon it." I think Johnson is right, but Johnson is assuming that the information is actually out there to be had, that we can get it. And that is really the question that lies at the heart of the discussions today. What information should we need, and is it available for us to get? So that's the crux of today's discussions. So let's take a quick look at the major players in this information plot. We have all of us as consumers, all of us as voters. We've got the private sector, which is the engine of our society, and in which most of us participate in some way as employers, as employees, as inventors, as investors. So we have this tremendous society bound together by government, which exists to try to protect our collective and individual interests. We have a huge amount of information flowing through these players. We each want information for a variety of purposes. At the same time, we very much value our privacy. That's part of our tradition. And so, depending on which shoes we're standing in at any particular time, we may view differently the trade-off between access to information and our desire for privacy. That's part of what I think makes this issue so difficult and so very interesting. We've all been riveted the last few months by Edward Snowden's activities and the questions that they posed about what should we know about what our government has done and who should be able to release that information. He took the keys to that government lockbox of information and just threw it out to the world. What we look at today, though, is information in a whole variety of contexts. Perhaps not as dramatic as the Snowden affair and not as many pictures of the Moscow airport, but really important issues that permeate environmental protection in the first panel, securities regulation, consumer protection, campaign finance, with different perspectives from different countries. But I think all of these topics go to the fundamental question of what do we need to know and can we get it? So just to warm up the intellectual adrenaline for the day, I thought I'd pose a few questions. Just very quick questions, give quick Rorschach answers, raise your hand, yes or no, no in between. So for starters, should you be able to see the president's tax return? Yes? No? Okay. Some dissent. Should you be able to see the governor's tax return? Yes? No? A little more dissent. Should you be able to see the tax return of the president and dean of Vermont Law School? Sorry, Marc. Yes?
He didn't file one.
Oh. No? No? Should we all be able to see your tax return? Yes? No? Okay, what are the differences? What drives the decision about what we should know and what we shouldn't know? Should the public have a right to know when you have a one-on-one meeting with your senator? Yes? No. Not everybody's answering. Come on, that's cheating. Should you have a right to know when the CEO of ExxonMobil meets with a senator? Yes? No? Should you have a right to know when the CEO of the Sierra Club meets with a senator? Yes? No? Okay, again, what drives the difference? What are the circumstances? What's important to you as a voter and a member of society? Should you know what's in the products that you buy at the grocery store? Yes? Yes. Okay, no? Oh, unanimous, okay. When you buy products, do you always read the labels? Yes? No? Okay. If you have ever purchased a share of publicly traded stock, do you first read the SEC filings? Yes? No? This goes to the question of what do we need to know and what do we actually do with what is available. And if a country competes with the United States, should we know their trade secrets? Yes? Should they know our trade secrets? Yes? No? Okay, everybody's no on those. Should we have a right to know the trade secrets of the company that's fracking next door to us? Yes? No. interesting conflict. Okay? Again, where do we draw the lines? How do we get information we think we need to know, but how do we still preserve innovation? So today's discussions, I think, will be very fascinating on a number of fronts. They share the common themes of, as consumers, what should the private sector tell us and why? What are we trying to really get at with disclosure? As voters and regulators, what do we need to know in order to responsibly play our role in society? So let the games begin, but before, I thank you very deeply for the members of the Law Review for all the planning that they have done to make today possible. Thank you all for coming and for the panelists throughout the day for the wisdom that they bring to the topic. So let the games begin in the Environmental Stadium. Thank you.